Here, conditional transfer on failure of prior disposition. Okay, under section 27 to 30 of the Transfer of Property Act. But here, section 27 of the TP Act explain about Doctrine of Acceleration. Okay, we'll go to Doctrine of Acceleration, section 27. Here, conditional transfer, section 27 says conditional transfer to one person coupled with transfer to another on failure of prior disposition. Okay, where on a transfer of property, an interest therein is created in favor of one person, and by the same transaction an ulterior disposition of the same interest is made in favor of another. The prior disposition under the transfer shall fail. The ulterior disposition shall take effect upon the failure of the prior disposition, although the failure may not have occurred in the manner contemplated by the transferor. This is section 27, para 1, explained clearly. And para 2, but where the intention of the parties to the transaction is that the ulterior disposition shall take effect only in the event of the prior disposition failing in a particular manner. So, the ulterior disposition shall not take effect unless the prior disposition fails in that manner. Okay, this is what section 27 explain of. We'll see illustration of this same section. Illustration 1. A is a person transfers rupees 500 to B. B is another person on condition that he shall execute a certain lease within 3 months after A's death, and if he should neglect to do so to C, B dies in A's lifetime. This disposition in favor of C takes effect. This is one illustration. And another illustration, second illustration, A transfers property to his wife. Here A is a person. He transfer property to his wife. Okay, but in case she should die in his lifetime, transfer to B that which he had transferred to her. A and his wife perish together under circumstances which make it impossible to prove that she died before him. The disposition in favor of S does not take effect. The main point here, the prior interest is valid and fails. Okay, prior interest is valid and fails due to valid condition being not fulfilled. Then the doctrine of acceleration comes into play, that is section 27 comes into action. Okay, this is the main theme. We'll see case law, Jullus versus Jacobs. Jullus, J-U-L-L-S, Jullus versus Jacob. Here A is a person at some property and he executed a will in favor of B person, B. Okay, with a condition that B shall enjoy the property during his lifetime, and thereafter the remainder of the property shall be devolved to the sons of B. B attested the will. So this is a fact. After the conclusion of the court, the judgment passed by the court held that B should not have attested the will under the provisions of law of wills. As B attested the will failed in case of B, but it accelerated to the sons of B. Okay, this is main concept, and the principle is the primary instance. The bequest was intended to B. Due to the fault of B, he could not get the property. At the same time, the sons of B, who are the beneficiaries of the property in the next stage, that is after B, become entitled of property immediately. They jumped in the place of B and acquired the property. They obtained the property at speed than B. They had overtaken B. This is called the doctrine of acceleration. Okay, can you understand? The doctrine of acceleration is very important. The above case, the Lord Romilly, the member of the Law Commission, explained this doctrine applies not only reality but to the personality. Okay, and another exception, we already discussed section 27 para 2. Here section 27 of the para 2 gives an exception to the doctrine, this doctrine, where the intention has been expressed that the gift over shall not take effect unless the prior gift fails in the particular manner prescribed. Okay, and we'll compare the section 27 and Indian Succession Act. Section 129 of the Indian Succession Act 1925 is equal to section 27 of the Transfer of Property Act. Okay, here section 129 of the Indian Succession Act 1925 explain bequeathed, bequeust, bequeathed to A, and on failure of prior bequeathed to B. That is, where there is bequeathed to one person and a bequeathed of something to another, if the prior bequeathed shall fail, the second bequeathed shall take effect upon the failure of the prior bequeathed, although the failure may not have occurred in the manner contemplated by the testator. Okay, as per the section 129 of the Indian Succession Act, illustration, 2 or 3 illustration we'll discuss. The number 1 illustration is A is a person bequeaths a sum of money for his own children surviving him, and if they all die under 18, to B, A dies without having ever had a child, the bequest to B takes effect. This is one illustration. Can you understand? And another illustration clearly explain A is a person bequeaths a sum of money to B on condition that he shall execute a certain document within 3 months, certain any one of the documents within 3 months after A's death. If he should neglect to do so to C, B dies in the testator lifetime, the bequest to B takes effect. Okay, are you clear? So This is section 27 and section 129 of the Indian Succession Act and section 27 of the TP Act explained clearly. We'll go to another section next video.